Welcome, everybody. My name is Jonathan Zackerson. I'm a co-founder of Protect Kids California. And with me today, I'm excited to have Emily Ray. She is the Senior Counsel for Liberty Justice Center and the lead attorney for Chino Valley, the Chino Valley case that's going on, talking about parental notification and balancing kind of what's going on there at the state with regards to the attack on parental rights that we see going on. And so I'm really happy to have her here with us. And she's going to give us a lot of context and background about what's happening in that case there. So welcome, Emily, and please share a few more things about yourself that I may have missed.
Sure. Well, thank you so much for having me. This is a really big, important fight that's happening in California. And specifically, Chino Valley is the only school district that has been sued by the state over parental notification policies. So we're the first ones in here, and we know how important it is to parents and teachers and students across the state and across the country. So we're happy to be leading this fight.
Excellent, thank you. So let's start off with where we got here before we talk about the case. Like, what led up to this lawsuit and why we're in this position?
Sure. So Chino Valley adopted a policy that requires schools to tell parents if their children want to go by a name or use pronouns of a different gender. The background there is that previously the state had offered guidance on school board policies, and what the state had done was recommend to school districts that they adopt policy requiring schools to keep secrets from parents unless their child gave consent. So, it's not even just about, keeping parents in the dark, but like actively lying to them. Even if a parent asks point blank, has my child socially transitioned at school, the teacher under that version of the policy that the state recommends would be required to lie to the parent. So Chino Valley saw this was happening and they said, absolutely not. That's not how we run things here. Parents need to be involved. It's important that schools and parents partner together. It's what's best for the child. And so they implemented this policy, and the state, the Attorney General, Rob Bonta, sued Chino over it.
I think that's a great summary. And to note, there's kind of two components, I guess, of this policy, right? We have a parental secrecy policy that almost every school district has today. And for those listeners, if you want to see if your school district has this policy, go ahead and search Administrative Regulation, or AR, 5145.3. It's a bullying policy, but the first page and a half is pretty generic. Then there's going to be a section, a transgender section, or transgender student section. And in that, you'll see paragraphs that basically say the school will not give this information to anybody else unless you have written permission from the student. And in some cases, it explicitly calls out parents in that. So almost every school district has a secrecy policy. But Chino Valley, they not only got rid of the secrecy part, but they wanted to make sure parents were notified and informed. And so that's kind of ultimately what the lawsuit is about, is that active notification. So there was a hearing last week. And we had some tentative results. We're waiting to get the final of that. Can you talk about just what happened at the hearing specifically, and where we're kind of looking over the next week or two?
Sure. So the judge granted in part and denied in part the state's application for a preliminary injunction. And what that means is the state asked the court to stop the school district, to enjoin the school district from enforcing this policy during however long it takes for the litigation to end, either to go to trial for a final judgment to be entered. The judge granted the injunction, meaning that Chino Valley cannot enforce the policy for sections 1A and 1B of the policy. However, we won on section 1C. The court said that the school district can continue to enforce. And just for the listeners, 1A required that parents be notified if their child requests to change their name or their pronouns. Section 1B required notification if they want to change bathroom facilities or join the sports team of the opposite sex. And section 1C requires notification if a child asks to change their official or their unofficial school records.
Okay, so so the first two, the judge basically sided with Bonta and says you can't enforce this for now as we continue to go through trial or however long this takes. But 1C is basically almost a reversal of the temporary restraining order because they were halted from doing anything. Now the school district can go forward with 1C and notify parents if a student requests to change their records, essentially.
That's correct.
Okay. And maybe we could talk about the timing. This is interesting. So there is a date in February, is this correct, of when they're
Yeah,
going to set a trial date?
I believe February 26th is our trial setting conference where we will then get our trial date. So we're still, months away from finding out what our trial date will be.
And that trial date could be months, several months away from February.
Correct.
Yes.
It's hard to guess now. I know that San Bernardino has some of the most overworked judges with the biggest caseloads in the whole state. So timing is, we don't expect it to, be expedited.
And on that, so what does it mean then what does it mean for Chino and San Bernardino County school districts? And what does it mean for the rest of the state with this specific lawsuit? Meaning, does it apply to them? And the answer is?
The answer is no. The ruling will apply, and I guess I say this with the caveat of we haven't seen the final order yet. So until I have that order in my hands, it's hard to say anything 100% definitively. But this is going to impact Chino, and there's a lot of competing decisions that are circulating around the country right now. I think it's important that people understand, depending on your jurisdiction, there might be an active case against the parental secrecy policy, kind of the inverse of Chino's policy. And now there's starting to be more lawsuits across the country for parental notification policies as well. And we're seeing those decisions go a lot of different ways. We're seeing a lot of them being appealed too. So we expect that some of those might change. So it is a bit hard to kind of keep up with the current state of the law here.
Yeah, so I guess the answer is this particular ruling is one, it's specific to Chino, it's a preliminary injunction, not even a trial. And there's plenty of court cases, even in California, where we had the Mirabelli case, a federal case that kind of found the opposite. Now, these are two teachers that were suing and would have ruled the other direction if that was the judge. So basically, there's a lot of litigation. It's going to continue to bubble up and probably make its way to the Supreme Court, I would imagine, at some point in one of these cases.
Yeah.
And so ultimately, the 7 other school districts or 8 other school districts that have passed parental notification policies thus far are not impacted. It's just Chino from this particular lawsuit. Yep. And I imagine unless there's lawsuits filed, they probably won't. Any other future school district wouldn't be impacted unless there's lawsuits filed.
Correct.
Yeah. Okay. Let's talk a little bit in the case. There was the judge in the tentative granted, and I'm sorry if I'm not phrasing this correctly as being a non-lawyer, granted the interveners for parents in the case. Do you want to talk a little bit about that and what that means and who's involved there?
Sure, that was a huge win. We, applaud Judge Sachs for that decision. We think it was the right decision, obviously. But basically, trying to put it into non-legal terms, when the state sued Chino Valley, it only sued the district. So only the district was able to kind of defend the lawsuit and protect its interests, right? Well, obviously, this policy impacts parents too. I mean, that's parents have rights that are unique to them that the district, we can't argue to protect rights that belong to parents. So the parents came in and said, okay, I want to intervene. I'm asking the court to let me be a defendant in this case. Let the state sue me as well. So we have 6 parent interveners and the court granted their request. So now they're going to come in along with the district and be defendants so that they can protect their own interests in this lawsuit moving forward.
Which I think, as you mentioned, is a great thing because obviously the school district defending itself on a policy, even if it's for parents, is very different than a parent defending their right to know, information about their kids, especially if they're struggling with, certain conditions that might be harmful to them.
Exactly.
And not just that, just the right to, as we have a century of case law from the federal level that say parents have the right to on their upbringing of their children.
That's correct.
That's fantastic. That's happened. So hopefully maybe that changes, the course as we go into trial. There was let's talk a little bit about, again, back to what happened. There was the reasons the judge denied part 1A and 1B was citing equal protection, and that there's a higher standard of scrutiny that's used when evaluating that, and felt like, well, the third item was kind of across the board. It didn't really violate equal protection, and the state's unlikely to succeed on the merits. Can you talk a little bit about that equal protection argument they're making, and why, why that may not be the case, why we think it's not the case?
Sure. So California is arguing that telling parents about what their kids are doing at school when they socially transition amounts to discrimination under California's Equal Protection Clause, the California Constitution Equal Protection Clause. We think that that is ludicrous for a couple reasons. Number one, there's no binding authority that suggests parents, being notified information about their own children can be discrimination, just as a matter of law. But also, the court believed that it was discrimination because it treated transgender children different from cisgender children, and only applying to students who ask to socially transition. But the parental secret, or the parent secret policy that the state advocates for, does the same thing. It treats transgender children, or children who want to socially transition, different from children who don't ask to socially transition, because by its nature, any policy dealing with this issue would invoke elements of gender. There's no way around it. So we made those arguments in court, and the court decided to rule with the state anyway. So these are issues that we plan to appeal and go to the California Appellate Court. I believe it's the 4th district that covers San Bernardino.
Okay, great. And maybe we ask a little bit more on that piece, because I heard some arguments there, and it's just very interesting. So they're talking about gender and sex, and this idea of this is discriminatory based off sex. And the judge was using some language that was almost indicating that this idea of wanting to change your gender is basically equal to sex. Was that an argument that I was hearing that the judge was kind of saying?
That's right. And I mean, this is a little bit trickier. It's not black and white, because we're in California, and California has interesting views on a lot of things in the case law. So the state was, taking some decisions that have come out and kind of conflated gender and sex and brought them under the same umbrella as far as discrimination actions. So that's their legal basis. Obviously, we disagree with it, and we argue the opposite, but that's the context for that.
Got it. Yeah, because I would say every child at the school this policy applies to. So, okay. So, let's see, is there any more details about the case before we wrap up here that you want to bring up or address?
No, I think just the next step being that we are going to move forward with an appeal, and from there, this is just the first step of the litigation. It's going to be a long road. We know that. We're ready for the fight. We are ready to appeal any future rulings that don't grant parents the rights that they have, and don't take that into account. So we're gearing up for a long fight.
Great. And real quick on that appeal, when you say appeal, meaning, are you going to appeal the preliminary injunction, or you wait till you get a trial? Okay, so you'll appeal
in California, preliminary injunction rulings are immediately appealable.
Okay, got it.
That is something that we can do now before we have a final judgment. Obviously, we cannot appeal the merits of the case because we don't have a final judgment on the merits of the case, but there is like a carve out in California law that allows you to do this.
Okay, interesting. So even before the trial setting date, we could have an appeal possibly.
Correct.
Okay, well, we'll look forward to that. Any message you have to school boards out there that are kind of watching this issue? Maybe they've passed this policy, maybe they're thinking of it past this policy. What message do you have for them?
Well, first of all, thank you for stepping up into the fight. This is just so important. And we understand that given the kind of legal climate right now, that it's not an easy thing to decide to do, but it is the right thing to do. And if you find yourself in a situation where you need legal help, or if you, hopefully you aren't, but if you get sued, you can reach out to Liberty Justice Center or any other number of nonprofits that are helping parents in this fight. But Liberty Justice Center is obviously at the forefront of this with Chino Valley. So that's libertyjusticecenter.org is where you can go for more information.
Excellent. That's great. Appreciate you willing to help school boards that are doing the right thing. If you're interested in what the latest model policy looks like, you can go to caparentalrights.com. That's caparentalrights.com. And as I mentioned, I'm representing Protect Kids California, which is working to get 3 issues on the November 2024 ballot, one of which is parental notification. And so if you're interested in helping out with those initiatives, you can go to protectkidsca.com and learn how to sign up and help out. So again, I want to thank Emily for coming on. I appreciate you taking the time on giving us a rundown of the case and what to look forward to. And this is something we definitely will be watching over the next several weeks and months.
Great. Thanks so much for what you're doing, getting the word out and supporting us in this fight.
Thank you.